Okay, thank you all for your patience. As you heard from Zoom, I do record these meetings and post them to my website. So if you want to rewatch or to see any of the slides or get the information, feel free to visit there, shofnerpllc.com. They're usually up within a couple of days. I'm going to go ahead and get the presentation up. Okay, and usually we've got Doug Ayers here from Comerica Bank, but he was not available today. So this is the Comerica Bank and Shofner Consulting Small Business Legal Concern presentation. I've been doing these once a month so far in 2021. I am going to take a break in July and August for summer. Doug and I are going to talk, and hopefully we can come back with maybe either a hybrid or a once a quarter in person. Now that things in Dallas tend to be opening up, I still want to give an opportunity for those of you that are either outside of Dallas or not comfortable, or just frankly don't have the time to drive to an on-site meeting to be able to keep participating. Today, we are going to talk about intellectual property. When most kind of Joe on the street is asked what they think of when they think of intellectual property, they're probably going to say trademarks and patents. But there's more than that. There's also copyrights and trade secrets. And both of these types of intellectual property are very important to all businesses, but especially small businesses. And so I like to make sure that all of my small business clients understand what copyright and trade secret cover, how it's different than trademarks and patents, and what you as a small business owner can do to protect yourself from potential issues that arise with these types of intellectual property. So a quick disclaimer, this is not any sort of legal advice. This is simply information, and we're not creating an attorney-client relationship between me and you. If that is something you're interested in, of course, reach out to me afterwards and we can talk about that. Quick introduction, I'm Kelsey Shofner. I am passionate about helping small businesses set themselves up for success. I work with my small business clients on forming their business entity, creating their contract package to use with their clients and customers, reviewing the contracts they receive from clients, customers, and vendors. I help set up employment policies and hiring practices, employee categorization, employee termination, and then of course, intellectual property, commercial lease review. I know this sounds like a lot, but my experience is in small business. I was in-house counsel at a large small business for about 6 years. And so I have a large breadth of experience helping small businesses stay compliant from a legal perspective. I went to the University of Texas and then the University of Colorado for law school. My focus when I was in-house was contract negotiation and HR, but I also did a lot of other things, including the intellectual property portfolio management. Okay, so quick true-false quiz. You can put this in the chat or you can just answer to yourself. But if someone does not use the copyright symbol, which is a C with a circle in it, the work is not copyrighted. This is false. A copyrightable work exists as soon as the work exists. The use of the copyright symbol is not required, but it is highly suggested because what it does is put others on notice that this is your copyrightable work and that you intend to protect it. Typically, when we get into copyright infringement or misappropriation cases, you're arguing about was it intentional or unintentional, and did the infringing party have notice? So what's the easiest way to put everyone on notice? Put the copyright symbol on there. Okay, there we go. So a quick overview of what a copyright is. Copyrights, and this is pretty much pulled directly from the relevant statute. This is a intellectual property right that protects an original work of authorship as soon as that original work of authorship is fixed in a tangible form of expression. Okay, so I recognize that is a lot of words, but basically what we're getting at when we say works of art, this is anything that comes from creativity. And tangible means it has to be recorded somehow. So a good example is if you are a casual piano player and you come up with a tune on your piano to play, you can't copyright that because it's not fixed, it's just in your head. But if you were to take the time to actually write out the score, that piece of paper is the tangible form of expression. And nowadays we have software on our iPhones and iPads that do this for us. And so that file is the tangible form of expression. If you'll excuse me just a minute, I wanted to see if we had anyone else come in. Okay. So here's some examples. What people think of a lot when they think of copyrights are musical scores, lyrics, performances that are recorded. Just standing up on stage is not copyrightable, but as soon as someone gets out that iPhone camera, that recording is. Other types of artwork, paintings, sculptures, photographs, books, short stories and articles, poems, new-ish blogs. There's actually now a specific copyright registration at the US Copyright Office for blogs because of how popular they are nowadays. Then movies, animation, choreography, and anything that has been recorded or written down. So just a quick history tidbit. The founders of the US were all very creative type people and wanted to be able to monetize the work that they did. They were all prolific writers. As anyone's watched Hamilton, you know that that was his thing, just writing and writing and writing. They wanted to be able to actually make money off of this. So this dates back to the founding of the US, having the right to monetize your works of art. And of course, we've moved beyond just artists, writers, screen producers, choreographers, and now we've moved into businesses themselves having a lot of copyrightable information in their arsenal. And I am so sorry about this internet. So like I said, it's inherent. The rights exist as soon as you create it. Use that copyright symbol to put others on notice. There is also a registration system at the United States Copyright Office that allows you to submit your work and have it filed at the Library of Congress, and then you have a certificate of registration. So you have enforceable rights with just the copyright. You put others on notice with the copyright symbol, and then you can access some additional benefits by registering the work. One of them is statutory rights to damages. This is lawyer speak for money. Inside the copyright statute, it talks about minimum amounts of money that has to be paid by an infringer if infringement is found in a copyright case. This is great. However, there was lots of instances where the amount of infringement equal to a couple $100s, maybe a couple $1,000s. And that's great. If you're a creator and someone is using your work, you should be able to get that money. But unfortunately, it was costing people more in legal fees and court costs to enforce those rights than they were getting from the statutory damages. So very recently, the Copyright Claims Board has been put together. It's not actually in effect yet, but it's coming. And this is going to be a board that's essentially small claims court for copyrights. Instead of coming with a lawyer, you come as yourself in order to bring these cases. The intention is to keep the cost of the cases down so that you can still access these money damages that you have a right to under the law without having to spend a bunch of money to get that money. So again, it doesn't quite exist yet. It's in development. It's coming. So not quite sure how it's going to work in reality and how effective it's going to be at its goals. But one thing we do know for sure is in order to use this new CCB, you have to have registered your copyright, or at the very least be in the process. I highly suggest copyright registration for anything that your small business, or you personally, if you have a side hobby as an artist, plan to make money off of anytime in the future. The cost of filing a copyright application is very low. It really is, a couple $100, maybe a few $100s. It's not into the thousands unless you have a lot of material to copyright, and the statutory damages that you have access to far exceed that. So here we are in the digital age. We have so much content in our lives, content on social media, content on our phones, on our blogs, on our websites. We look at content, we take in content, and we all also produce content. I'm an attorney, I still produce content. This is content. I have a blog, I have a LinkedIn, I have an Instagram. I'm constantly creating things that are copyrightable. So when we're looking at what we want to do with our work, we need to think about how we're protecting it. So just, I would say after this presentation, go and look at your small business's website. What do you have on there that's going to, that could be something you monetize? I have several clients who are coaches. All in that industry, it's very common to have worksheets, workbooks, presentations, kind of things that their clients walk through themselves. Those are kind of the heart of that coach's process. Maybe they also have some kind of other not tangible things, and we'll talk about that in a minute with trade secret, but we want to make sure that we're protecting those forms that we're using. Of course, if you're a photographer, this is hugely important because the use of photographs online has gotten completely out of control. And so this slide, what I'm really getting at here is, in addition to what you own that you should be protecting, we also have a lot that we have access to that we don't necessarily own or have rights in. So if you look at your website, do you have stock photos? Where did you get those? Did you purchase them? Did you download them from something like Shutterstock or Canva's free library or Microsoft Office's free library? Or did you just pull them from another website? This gets people in trouble. When we do not know who owns the work and we just assume that it's open and available to us, we end up getting into situations where we are actually infringing on other people's work. Do I need a license? Yes, you need a license. I now have taken the tack, I'm of the opinion that all of my clients should either produce their own content or have some sort of written documentation that you received the license. And so just downloading from Shutterstock, it's unlikely you're going to have a very good paper trail. Now, if you're using the Canva or the Microsoft Office free library, you at least have the terms of use with that software that includes these photographs. But I have heard of horror stories of photographers finding their work on these free sites. And then anyone who's downloaded those thinking they're free available images, it turns out they're not. Who's left holding the bag? It's the person who's downloaded and used the image. Is Shutterstock going to get in trouble? Sure, but the end user is who it matters to. And just a quick example, I had a consult with someone recently who had received a letter from a law firm saying, you are in violation of our client's trademark or copyright, excuse me. You used this image on your blog twice and you owe us $2,000. She came to me, she's like, what do I do? And I told her, unfortunately, while the tone of this letter is a little iffy, they're right. What she had done is copied a photo from a news article about it was a picture of the Olympic gymnastics team. And she had linked it and she had said, I got this here, but that's not enough. You don't have the right. Just because you've given attribution does not mean you have the right to use it. So not only do we want to know if we're going to be monetizing this work and if we should be registering and enforcing, but we also have to think about the content we're using ourselves that doesn't belong to us, and do we have the rights in it? So be very wary of stock photos. Attribution does not equal a license. I always preach to my clients that having a policy internally, especially if it's more than just you and your business, about what content you can use is extremely important. So I've gotten through copyrights. These are the registerable, don't have to register, but registerable rights in fixed mediums of expression of artistic works. So as I talked about, when we have someone like a coaching company where you have both worksheets, but then you also have techniques. What are those and how do we protect them? So another little true false, you cannot register a trade secret. This is 100% true because a secret is a secret. And if you write it down and put it in a public deposit, it's no longer a secret. So patents and trademarks, you file with the USPTO, and you have to actually, in those patent applications, show a picture and write out every single little component of that invention. With a trademark, you file and say, here's the mark I'm going after, here's the word, or here's the picture. In copyright, you do send in your what's called a specimen to the US Copyright Office, who files it at the Library of Congress. Now, those are not as publicly available as trademarks and patents, because the last thing the Copyright Office wants is someone going, oh, I'll just go to the Library of Congress to watch the next Marvel movie. I don't need to go to the movie theater. No, they hold on to those, and technically you have divulged to the public the name, the author, the title of this work. So with a trade secret, you have to make sure that you have in place, policies and procedures for keeping those secrets secret. So cannot register, it's a secret, but we have to take what are called commercially reasonable steps to protect that secret. And it has to flow through our organization. If it's just you, great. But I still highly recommend that you write out, even if it's just one page, of what are my trade secrets and what am I doing to protect them. So when we're looking at our employees and our contractors, while a contractor is typically under a contract, an employee in the US and Texas, you're not going to necessarily have on a contract. In fact, most likely they aren't. Usually we have at-will employees, and so we don't want them to be on a contract. So we need a separate contract about company trade secrets and the use of them. These are commonly referred to as NDAs, non-disclosure agreements, but we also have some other components that go into those employee non-disclosure agreements. And then when we're looking at our vendors, third parties who need access to some of our information in order to help us run our business, it's really important to know how much access they have and to make sure that they only have access to what they need. So if you have an IT vendor who's going to have access to your whole system, you need to make sure you have non-disclosure provisions in that agreement with them, even a separate NDA. If you have a marketing agency who's going to help you, do they need access to all your files? Absolutely not. In fact, you might not even want to give them access to your marketing files. You may want to just send to them what you want them to see. Again, though, even when it's limited, we want to have those non-disclosures in place. And then, so those are what we call need to know clauses. If someone's going to have access, and then they're probably also going to distribute access out. So if your marketing company has, you have a relationship manager, but then you have the different people working on your account, those people working on your account need to be under a need to know requirement. And then finally, our internal file structures. Again, if you have employees, it's extremely important to make sure that you know who has access to what. As an attorney, I have an ethical and legal duty to make sure that my client's information is kept secret, or kept confidential, not secret, confidential, that it doesn't get released in a data breach. So, but also to make sure that the information is not going to someone else in my organization who has no need to know it. So I have a legal assistant who does a lot of very helpful work for me, but she does not need to see my client files. And on occasion, when I need her to draft a document, I have that document in a separate place, and she's given just the very basic information she needs in order to start that first draft that I take and then add in all the client confidential information and save in those protected files. So those internal file structures are very important. I don't know if it's obvious from this slide, but working with a reputable IT security firm is really important for making sure that your, not only that your trade secrets are protected, but also that you're protected from data breaches, phishing attempts, and whatnot. As I mentioned at the beginning, I record these presentations and put them on my website. I did a wonderful presentation a few months ago with an insurance broker and also an IT consultant talking specifically about data security. So if that's something you're interested in, I highly suggest you go there. I want to take a step back to the second bullet point, commercially reasonable steps. What is that? I don't know. There is no specific definition. Actually, I do know, but there is no definition that I can give you. It really depends on your industry. One of my favorite examples that several of you have probably heard is the Coca-Cola example. The formula for Coca-Cola is one of the tightest held secrets in the world. And I looked this up before I started using the example because I'd heard it. I didn't know if it was an urban legend, but it appears to be true that there are like 2 people in the entire company that know the recipe. They are under extremely strict NDAs. They never travel together, so that if something happened en route, that the secret is still safe with one of them, and that there are very intense processes for transferring that recipe when one of these secret keepers leaves. Now, is that the level of steps, is that the number of steps you need to take in your business? I don't know, probably not. What's reasonable in your industry with the information you have and the people that you work with? How are you going to stop people from taking out those secrets? Another example that I think hits a little closer to home is a bakery. So I have someone in my network who used to run a bakery, and she found that she would bring in line cooks or other bakers to help her. And sure, they can all make a cookie, they can all make a cake, but she was using family recipes. They would learn those recipes, learn those techniques, leave, start their own, and start competing with her. Her trade secrets are not necessarily a chocolate chip cookie recipe, although it could be, because it could be a really, I'm of the Friends generation, our Nestle Toll House recipe. That has some extra thing, but it's also how you do it. How long do you let the dough rise on your bread? How exactly do you mix together the ingredients? Does it make a difference? It does, it's chemistry, right? So making sure that if you were running a bakery, that your bakers have some sort of non-disclosure or non-compete agreement where they understand that, sure, they might know how to bake, they might know the techniques, but they can't use your techniques they learn specifically from you if they want to go off and start their own business. I highly recommend against pulling non-disclosure agreements off the internet. Non-disclosures, especially those that have non-solicit and non-compete provisions in them, are very tricky. Different states have different laws on what is enforceable. I cannot tell a baker, you cannot go be a baker for 2 years after this, because if they are trained from Le Cordon Bleu in baking, they have to be able to make a living. I have to very narrowly carve out what they are not allowed to do with the information they learn from my business. And then on the flip side, some of these NDAs are just NDAs, non-disclosures. Don't have the non-compete, don't have the non-solicit, and so you're not fully protected. So we have copyrights, we have trade secrets. How do we pay attention to what's out there? We monitor it. All intellectual property, including trademarks and patents, require that you self-enforce. We have these registration databases and government agencies that manage them, but they're not helping you figure out if someone's infringing. So we do have trademark and domain name monitoring that we can do, but copyrights are harder. There are image tracking software out there. If you're a photographer and this is how you make your living, it might be worth it. It might be worth putting in some meta tag that helps you identify when your photo pops up. But paying attention to competitors, paying attention to former employees and former clients, it feels kind of icky sometimes, but it's really important to know if someone has gained information from you and is using it. Sure, we can all put that copyright symbol on, like I talked about, we should, but we live in the age of Photoshop. It's so easy to take those things off. Unfortunately, even watermarks can be removed if you're tech savvy enough. So you've got to pay attention to what's going on. And same with trade secrets. You know, again, we don't want to get obsessive and track people, but knowing kind of what a former employee, contractor, customer, vendor is doing is important, so that you know if they're getting into any sort of infringing on your trade secrets. So we're right at 30 minutes. I really appreciate y'all being here. I can stick around for a few minutes to answer questions. Let me get my chat up here. And then, as I mentioned at the beginning, I do, my practice is in-house outside counsel. So I'm doing all facets of legal work that small businesses need. Clients who work with me through legal risk audits and strategy sessions. In legal risk audits, I look at what current businesses are doing. And in strategy sessions, we talk about new things that need to be done. The vast majority of my work is done on flat rate, project-based. And then I also have a monthly in-house counsel subscription. So again, as I mentioned in the beginning, we're going to take a little summer break, come back in September, hopefully with more of a hybrid format that is working in this brave new world we're in. Here is a quick slide with my practice areas and then my contact info. Please feel free to reach out to me. Email is the best way to get a hold of me, but also follow me on LinkedIn and Instagram if that's your thing. I have weekly blog posts, tips, and especially on LinkedIn, I like to share resources from my network that are relevant for small businesses. Okay, well, I'm going to stop the recording. Thank you all so much. Like I said, feel free to reach out to me. I hope you have a wonderful day.